Replacing Professor Driver will be John Q. Barrett, Cardozo Professor of Law at St. John's University, where he teaches constitutional law, criminal procedure, and legal history. Professor Barrett has produced extensive scholarship on Robert H. Jackson and serves as the Elizabeth S. Linney Fellow at the Robert H. Jackson Center. He is a graduate of Georgetown University and Harvard Law School. Please join me in welcoming Professor John Q. Barrett back to the Hall of Philosophy to introduce Justin Driver.
Thank you so much, Shannon. I thank Arnie and Jill Bello, whose family foundation is part of supporting this lecture, and the Robert H. Jackson Center, which is really honored to co-sponsor this lecture. And I thank each of you for assembling and creating this forum. There is power in this room, and it goes forth from this place every year, and that's very heartening. This is my 23rd consecutive summer of having the privilege of lecturing from one platform or another at Chautauqua Institution, and that is truly a treasure, especially after those few years where it was happening online. It's great to be back in a packed Hall of Philosophy. This is the 19th annual Robert H. Jackson Lecture on the Supreme Court of the United States, and that gives me three components to introduce. First, Robert H. Jackson, second, the lecture, and third, the lecturer. So I will do that briefly and then get out of the way. Justice Jackson is a phrase that is in the air of law and the United States and the world, and particularly Chautauqua County and Chautauqua Institution, for a long, long time. And I'm not referring to Justice Ketanji Brown Jackson, although her inheritance, her picking up and carrying forward that moniker is a wonderful thing. She is the third Justice Jackson to serve on the U.S. Supreme Court. The first, the 19th century Justice Jackson, was named Howell Jackson, and that's really all we need to say about him. Justice Ketanji Jackson is the third. She is the 21st century Justice Jackson. This lecture and my project as a biographer is the 20th century Justice Jackson, Robert H. Jackson, who came from this ground. He was born south of the state line in Spring Creek, Pennsylvania, grew up in Frewsburg, New York, finished his general high school education in Jamestown, had a little bit of law schooling in Albany, became a lawyer in Western New York, mostly Jamestown, a little interlude in Buffalo, and in 20 years rose to be a very significant general practice force in the bar of the United States. He was also a Democrat and was involved in New York State Democratic politics. And in 1928, that pulled him into the gubernatorial campaign of Franklin Roosevelt, who won the job, who got reelected in 1930, who won the next job in 1932, and pulled Robert H. Jackson to Washington to the New Deal in 1934, which became a string of Roosevelt appointments. Over the next 7 years, Jackson rose to be a leading national name and legal figure, first as general counsel of the Revenue Bureau in the Treasury Department, then as Assistant Attorney General, first heading the Tax Division in the Department of Justice, then heading the Antitrust Division. Then he became Solicitor General of the United States. Then he became Attorney General of the United States. And in 1941, he was nominated and confirmed to be an Associate Justice of the Supreme Court. And all 5 of those senatorial confirmations of Roosevelt appointments were over and done when Jackson was 49 years old. And then he served on the Supreme Court for 13 years. But perhaps most notably, he skipped out for one of those years and served by appointment of President Truman as the U.S. Chief Prosecutor of the Nazi war criminals at Nuremberg for the first year following World War II. So that is the second Robert Jackson, the Robert Jackson of our soil, the Robert Jackson of the 20th century, the namesake of this lecture. In the theme of this week, I'll note that he's generally regarded as maybe the very best, but certainly in the handful of the best writers who have ever served on the U.S. Supreme Court. His words live on. They first grabbed me as a student. They grabbed my students. I'm sure they grabbed Professor Driver's students and everyone, and they remain highly accessible and deeply relevant. So the Jackson Lecture in the Writing Week is a perfect fit here at Chautauqua. Second topic, this lecture. This is its 19th year, a great credit to Chautauqua Institution for its vision and its commitment to bringing study of the Supreme Court to the grounds, to the summer program on an annual basis, in the person of a deeply expert scholar, student, historian, commentator on the court. And you can look at the past roster of speakers. I think many of you might have been here last summer when Reva Siegel of Yale Law School was the Jackson lecturer. She focused principally on the then brand new Dobbs decision, rescinding abortion rights. And it matters because the Supreme Court is our Supreme Court. It's in our life. It affects us deeply. And it sort of tees up things for us to make sure we're noticing and thinking deeply about in the summer when they go on recess, and a place like Chautauqua and lecturers like this series brings forward is the perfect way to do it. That brings me to this year's lecturer. Justin Driver is the Robert R. Slaughter Professor of Law and counselor to the Dean at Yale Law School. He is a District of Columbia native, a product of the DC Public Schools, a graduate of Brown University, of the University of Oxford, where he was a Marshall Scholar, of Duke University, where he obtained a certificate to teach public school, and Harvard Law School. This guy does schooling. He also then became a law clerk, first to Judge Merrick Garland, who has a subsequent job, but then Judge Merrick Garland of the DC Circuit U.S. Court of Appeals, and then at the U.S. Supreme Court to Justice Sandra Day O'Connor and Justice Stephen Breyer. Professor Driver then picked up that moniker, beginning his teaching career at the University of Chicago, and some years ago moved from Chicago to Yale Law School, where he is a leading force in the classroom, in writing, in public commentary, and in deep thinking in the areas of constitutional law, education law, and racial equality. In particular, I commend to you his book, The Schoolhouse Gate, which he'll be signing and you can buy later, which is a history of the constitutional law of schools, the Supreme Court on schools and schooling from really the 19th century to the present time. Every year as the planning process dreams about an ideal Jackson lecturer, one thing is what the Supreme Court is up to, and another thing is who are the lottery picks out there. And Justin Driver has always been on the list of lottery picks, and it's wonderful that this has come together. But it particularly fit this year because, as you may have heard, the Supreme Court in its most recent term had things to say about education and schooling and race and equality and what our Constitution, in the view of 6 justices on the court, does mean and doesn't mean with regard to those incredibly relevant, permanently significant topics which belong to the lawyers and belong to the Constitution, but also fundamentally belong to each of us. So it's my great pleasure to introduce Professor Justin Driver.
Thank you very much for that kind, generous introduction. I first heard of Chautauqua about 15 years ago when I was a law clerk for Justice O'Connor. She said to me, if you ever receive an invitation to go to Chautauqua, you better jump on it. And I'm so delighted that I did so. This is a storied institution and the most breathtaking venue that I've ever had the privilege of giving a talk. So I thank you for including me as part of it. Before I get started in earnest, I want to note that I have a distinguished guest with me. That is Claire Ellison Driver, my 13-year-old daughter. So I mention that for 2 reasons. One is I want you to keep the booing to a minimum. I understand that there will be some booing, but let's not go overboard. And second, it seems to me that bringing her with me exemplifies the spirit of Chautauqua, which at its core acknowledges that intellectual engagement and family time are not mutually exclusive, but instead are mutually reinforcing. Okay, late last month, the Supreme Court of the United States, in a case called SFFA versus Harvard, killed affirmative action. Now that affirmative action is dead, it seems to me that the least that we can do is to afford it a proper burial. Affirmative action has played a significant role in creating and bolstering the black middle and upper middle classes, and we should, in my view, salute it for that vital work. We should place it right up there with the GI Bill as an engine of mobility that has shaped and improved modern America. Not long ago, the nation's leading universities were devoid of black students. Consider the racial composition of some college classes that entered in the fall of 1960. Harvard University had 9 black students in a class of more than 1,200. Yale, my current employer, had 5 black students. And Princeton had a grand total of 1 black student. In a decade, there was a sea change, and there were appreciable numbers of black students on those campuses and many of the other leading campuses in this nation. And we have affirmative action to thank for that sea change. And even if you're an opponent of affirmative action, I hope that you will believe that this transformation has been a beneficial one for a nation that is an experiment not just in democracy, but in multiracial democracy. Okay, what I'm going to do today is I'm going to talk a bit about the history of the Supreme Court's engagement with affirmative action. I'm going to talk about the Students for Fair Admissions versus Harvard, the current case. And then I will talk about the future in this area. And then I will welcome your questions, your comments, and your objections to what I have to say here. Okay, first, history. The Supreme Court's jurisprudence in this area is marked by a profound ambivalence in this area. You see this in all of the cases that the court has dealt with involving race-conscious admissions policies. The first case that the court engaged in this area is one that's been largely forgotten even among sophisticated constitutional lawyers. There's a case called DeFunis versus Odegaard that was decided, in some ways not decided, in 1974. The facts of this case are from the University of Washington. There was a transformational leader at the University of Washington, making it a first-rate leading public university, a man called Charles Odegaard. And so in 1963, at the graduation ceremonies, President Charles Odegaard looks out at the parade of white graduating students, and he asks the following simple 5-word question. He said it twice. Where are the black students? Where are the black students? Odegaard was concerned about the absence of black people at the University of Washington, and he thought it was vital for the university to prepare students for a multiracial democracy, and that doing so required diversity in higher education. And one of the programs that was started under Odegaard's leadership involved the University of Washington Law School, which implemented a race-conscious admissions policy. It's this case that makes its way to the Supreme Court in 1974. Ultimately, the Supreme Court is so confounded about what to do. What do we do when people take account of race for purposes of bringing people together rather than keeping them apart, as was involved in Brown versus Board of Education? Does that violate the Constitution of the United States? The Supreme Court's so confounded that it punts the case on mootness grounds. DeFunis had been admitted to the University of Washington. He was about to graduate, and they say, we're not going to get involved here. This is, in effect, too complex. 4 years later, this issue returns in a case that some of you all know called Bakke, involving the University of California Medical School, the Davis Medical School. There, in 1978, there was a 4-1-4 split. Justice Powell wrote the controlling opinion for the court, and he said that UC Davis Medical School's approach was unconstitutional. That program had a set-aside of 100 slots, 16 for racial minorities. So Justice Powell writes an opinion only for himself, but that controls, saying, this is a quota, therefore it is impermissible, but that doesn't mean that there are not some instances where colleges may take account of race. Colleges may be able to take account of race in at least some instances. He reached out and elevated Harvard College as a reservoir for all that is pure and holy, and said the way that Harvard College goes about admitting its students is permissible. Sometimes they'll give a break to a farm boy from Idaho. That person can bring something to Harvard College that a Bostonian cannot. And the same is true for racial minorities. A black student might be able to bring something to Harvard College that a white student cannot. Okay, flash forward 25 years to the next major interaction here. This is the Grutter and Gratz cases in 2003 involving the University of Michigan. There, my beloved old boss, Justice O'Connor, wrote an opinion for the court upholding race-conscious admissions policies at the University of Michigan Law School and simultaneously invalidating those policies for the University of Michigan undergraduate. She said, in effect, that the University of Michigan undergraduate program resembled too closely the UC Davis Medical School program with its set-aside, its quota. It was too mechanical in its approach to race, but it was nevertheless permissible for the University of Michigan Law School, which took a holistic approach to racial integration. This led Justice Scalia to say that there was a Grutter-Gratz split doubleheader, right? They gave the thumbs up to the law school and the thumbs down to the undergraduate. The most remarkable feature of the opinion was toward the end, where Justice O'Connor said, in effect, it's been 25 years since Bakke was decided in 1978. And then she says, in another 25 years, we expect that the use of racial preferences will no longer be necessary. Okay, so this thumbnail sketch suggests a few things. One is that affirmative action has been administered last rites many times. And also that affirmative action received new life from a series of improbable saviors. Lewis Powell was the chairman of the Richmond School Board at the time of Brown versus Board of Education, and he fought that decision tooth and nail. He did not like Brown versus Board of Education. The idea that segregationists would subsequently permit race-conscious admissions policy is very difficult to believe. My beloved boss, Justice O'Connor, wrote very critically of race-conscious policies in some instances, including in the realm of democracy. She says that taking account of race bears an uncomfortable resemblance to apartheid. And nevertheless, in 2003, she writes this opinion upholding the legitimacy of affirmative action. Justice Kennedy also repeatedly voted to outlaw race-conscious policies, and nevertheless, in the Fisher cases involving the University of Texas, he issued an opinion saying that it was permissible, albeit grudging. So you might say, with some force, that it is less notable that affirmative action has died, and more notable that it has managed to survive for as long as it did. After all, it's important to note that these justices were all Republican-appointed justices, and there are 6 Republican-appointed justices on the current court, although they are quite distinct from O'Connor and Powell and Kennedy, because the overwhelming majority of them are battle-tested, having experience in Republican presidential administrations, and they are seasoned, Washington folks, and they are, in my view, inflexible in their approaches to these questions. Okay, I'm now going to shift to start talking about the decision itself. The case involved Harvard and the University of North Carolina. Those are the oldest private university in the country and the oldest public university in the country. As a formal matter, Harvard is not governed under the 14th Amendment's Equal Protection Clause. It is instead covered by Title VI of the 1964 Civil Rights Act, though the court has seen these issues as being sort of interchangeable, and I should say the Equal Protection Clause and Title VI are treated as coextensive. So Harvard, in effect, is covered by the Equal Protection Clause. Chief Justice Roberts writes the opinion for the court. It's a 6-3 decision. All of the Republican-appointed justices are in the majority. The 3 Democratic-appointed justices are in dissent. Those are, of course, Sotomayor, Kagan, and Jackson. A large theme of Chief Justice Roberts' opinion turns on this idea of constitutional colorblindness, that we should be colorblind when it comes to the 14th Amendment. And maybe the most famous line from this opinion, at least in its early days, is when he says, eliminating racial discrimination means eliminating all of it. This is an echo from a case that was decided when I was a law clerk at the Supreme Court in 2007, the Parents Involved in Community Schools case. So that involved the K-12 element, and he said there, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. This is the notion that Brown versus Board of Education is indistinguishable for constitutional purposes from programs that are designed to bring people together. Jim Crow, which kept black people separate and on the bottom of society, is indistinguishable from programs that are designed to take account of race in order to bring people together, at least for constitutional purposes, for Chief Justice Roberts. This language sounds very sweeping, constitutional colorblindness, but Chief Justice Roberts doesn't go whole hog on this front. In footnote 4 of the opinion, Chief Justice Roberts exempts military academies from complying with this race neutrality. Obviously, we're talking about West Point, we're talking about Annapolis, and he says maybe there are special circumstances that make it permissible for the military academies to include racial diversity in their admissions process. This led Justice Jackson in dissent to say that this is a very awkward position. After all, it sort of leads to the idea that it's okay for people of color to prepare for success in the bunker, but not the boardroom. Chief Justice Roberts also said that it would be permissible in some instances for colleges to consider race if it were included in an essay. He says, nothing in our opinion should prohibit an individual college from considering an application's discussion of how race has affected his or her life. He says, be it through discrimination, inspiration, or otherwise. Discrimination, inspiration, or otherwise. I have a friend who's very interested in trying to open access to law school, who's thinking about getting that as a tattoo. Discrimination, inspiration, or otherwise, okay? As it turns out, nobody believes in absolute colorblindness, or even that it's impermissible for the government to allocate opportunities on the basis of race. Suppose that a police entity is trying to infiltrate a racially identifiable gang. Imagine you're trying to get into the Crips, okay? You're trying to figure your way out. And you go to someone in your charge and you say, Officer Sven Johansson, you are the most qualified person for a high-level undercover operation. Officer Johansson, good luck with the Crips. Ridiculous, absurd, laughable, exactly as you are doing. That means, though, that the question is not whether it's permissible for the government to be race conscious, but when it is permissible for the government to be race conscious. Okay, I want to talk about some underappreciated aspects of the opinion. It's very short on specifics. Chief Justice Roberts says, in effect, these programs consider race and they violate the Constitution. Many people have interpreted the opinion, with justification, to say that having race as a box that one can check is no more. Maybe you can write it in these essays, but you can't simply check the box, that's too crude. I believe that conservatives may well find themselves pining for the good old days of box checking. Under the old regime, an applicant like myself could check the black box, and then I could write an essay about why I want to study Proust, or string theory, or the Odyssey, or anything else under the sun. Under the new regime, the Harvard case regime, sophisticated students of color are incentivized to write about race. And overwhelmingly, those essays will be experiences with racial discrimination and oppression, not inspiration or otherwise. You can imagine conservatives saying that this is regrettable because writing an essay is constitutive in a way that a box checking is not. And you can imagine conservatives saying that after you write this essay, that you are going to lug racial grievances with you to campus right along with your dorm trunk. And, again, you can imagine conservatives saying that this is going to increase the salience of race on our college campuses, and that it will delay that precious day when skin color is of no greater significance than eye color. Conservatives, you can imagine them saying, in another setting, that this decision, in effect, held the opening ceremonies of the microaggression Olympics. I'm doing my best to channel the Wall Street Journal editorial page here. And, some people have said, I've heard college counselors say that already it's too often the case that white students write about their passions and black students write about their pain. Some of my students talk derisively about being asked to perform their trauma. And the SFFA versus Harvard decision may well sort of make that the new coin of the realm. By the way, it's not only conservatives who would feel this way. Some liberals have objected to the notion that race should be all-defining and all-important. Professor Henry Louis Gates of Harvard has said that he rejects, here I'm quoting, the notion that race must be the most important thing about me. Is that what I want on my gravestone? Here lies an African American. I want to be black, to know black, to luxuriate in whatever I may be calling blackness at any particular time, but to do so in order to come out the other side, to experience a humanity that is neither colorless nor reducible to color. Bach and James Brown, sushi and fried catfish. The italics is Professor Gates's, but the sentiment is one that many of us can sympathize with. It's important to think about how absolute colorblindness would actually work in practice. There could be some significant administrability problems here. After all, some names are racially identifiable. We've spoken about Sven Johansson. What about Jamal Johnson? Javier Hernandez? June Ho Choi? What about interviews? Racial differences are often discernible. Are we to move to a world like the orchestra where some auditions happen behind a screen? Of course, that wouldn't solve the problem because some voices are, with a high degree of certainty, racially identifiable. Even setting aside essays, what about the list of activities that people have participated in? I'm the president of the Black Students Association. That might be a tip-off in some cases. One of the other underappreciated aspects of this momentous and, in my view, as you can tell, deeply wrong-headed opinion is the fierce battle over Justice Harlan's dissenting opinion in Plessy versus Ferguson. Justice Harlan was the one dissenting justice in Plessy versus Ferguson from 1896, which, as many of you know, upheld Louisiana's separate railcar statute, right? The opinions in SFFA versus Harvard cite Harlan and mention him 29 different times. It's an astonishing number. It's, in my view, difficult to escape the idea that Justice Harlan is cited a good deal more frequently than he is read. I believe that the Plessy versus Ferguson dissent is the single most overrated opinion in the history of the U.S. reports. Yes, it's better than the majority opinion, don't get it twisted. But it seems to me that that assessment damns with faint praise, and people make a mistake when they view Justice Harlan as the embodiment of modern racial enlightenment. Justice Harlan did not say what people think that he said, even in the most revered parts of the opinion. The opinion says, among other things, there is no caste here. He also says, our Constitution is colorblind. Let me pause for a moment and say that those two ideas might be in opposition. The conventional view in law schools is that those are two different ideas. Constitutional law professors speak about, when he says our Constitution is colorblind, that is an anti-classification principle. And then when he says there is no caste here, that is an anti-subordination principle. The anti-classification idea says that it's impermissible for the government to take account of race and to have people check the box. And the anti-subordination view is a different idea. It says it's okay for there to be some racial classifications, provided that the racial classifications are not being used to subordinate a group of people. So you can understand that there's something for everyone there. He goes on to say, in respect of civil rights, all citizens are equal before the law. Now, when we hear that language today, we get excited and we say, that's a wonderful opinion, because we hear civil rights to be a broad umbrella term. Justice Harlan meant it in a narrowing fashion. He meant civil rights as distinct from other rights, including social rights. In the late 19th century, they had a fractured notion of equality. Civil rights meant things like entering into a contract and things like that, or indeed buying a railroad car pass, whereas social equality meant things like interracial marriage and, importantly, integrated schooling. The idea would be that if you rub shoulders with someone as an equal, that integrated classrooms will lead to integrated bedrooms. And so Justice Harlan was not the proponent of absolute racial equality. Justice Harlan did not think that social equality was permitted. So when he says in respect of civil rights, he viewed the rail car as involving civil rights, not social rights. And he writes an opinion 3 years later in a case that I write about in my book, saying that it's okay to have separate schools and indeed to have no schools for black people at all. So Justice Harlan is not your guy. It's especially odd because many originalists, people who believe that the Constitution is meant to be interpreted consistent with the original public meaning, elevate this dissenting opinion from 3 decades after the ratification of the 14th Amendment. That's a very odd understanding of originalism. A dissenting opinion from 3 decades later? Why would that control original public meaning? Justice Harlan's opinion and the vicious fight over it in SFFA versus Harvard is especially odd for a couple of different reasons. One is that Harlan's opinion, if you read beyond the sound bites, was avowedly white supremacist in origin. He says, I believe the white race to be dominant and it will be the dominant race in this country for all time, he says. He goes on to say, and this is especially confounding, recall that in SFA versus Harvard, one of the major claims was that the Harvard admissions office was discriminating against Asian American students. That by assigning those students lower personal ratings on average, it was artificially capping the number of Asian American students who matriculate. Justice Harlan's opinion, in a critical moment, says, the Chinese race is so different from our own that we do not permit those belonging to it to become citizens of the United States, he says with approval. He says, basically, it's bizarre that a Chinaman can ride the same passenger coach with white citizens of the United States. So why in the world are Chief Justice Roberts and his colleagues bitterly saying, we have Harlan, no, we have Harlan? I think it's time to leave Harlan's opinion to rest. A couple of things to say about Justice Thomas. Okay. Not sure if those of you watching from home can hear the murmurs of recognition about Justice Thomas. He's actually a more interesting figure than people give him credit for. Justice Thomas can be viewed as scrambling the anti-classification, anti-subordination idea that I gave you a moment ago. Justice Thomas sometimes speaks in the register of anti-classification, and indeed in this opinion that he writes, his concurring opinion, he says anti-subordination is a bad idea, it's in vogue, like parachute pants or lava lamps, but we should not pledge allegiance to anti-subordination. Nevertheless, he is irresistibly drawn to these arguments because he believes that affirmative action subordinates racial minorities by suggesting that black people are not up to code and cannot make it on their own without racial preferences. So in that sense, Thomas believes that whether you are an anti-classificationist or an anti-subordinationist, that affirmative action must go. And in this sense, he is in conversation with one of his predecessors, including Justice William O. Douglas, who said that affirmative action programs convey stigma and caste and place a stamp of inferiority on black and brown students by saying they cannot make it on their individual merit. Justice Thomas says almost identical things. He says, many years later, these programs stamp minorities with a badge of inferiority. So Justice Thomas has made very interesting moves here in ways that are not appreciated by constitutional law scholars. It's possible that the anti-classification, anti-subordination divide has been destabilized. It's not to say that there are no responses that anti-subordination scholars have, but they need to recognize the challenge that has been thrown down by Justice Thomas and mighty figures, including Richard Posner, then Professor Scalia, then Professor J. Harvey Wilkinson, and plenty of liberals as well. Professor Derek Bell is a founder of critical race theory, and early on he said something similar to what Justice Thomas would say. You think of Derek Bell as being on the far left and Justice Thomas as being on the far right. Listen to what Derek Bell had to say a long time ago. He said, affirmative action envelops minority applicants in a cloud of suspected incompetency, reinforcing the presumption of intellectual inferiority. So I say Thomas is more complicated for a few reasons. One, I want to salute him for overcoming incredible challenges in his life. He says with some force that when he was a boy growing up in Georgia under the yoke of Jim Crow, that it was unimaginable for him that he would ever see the Supreme Court of the United States, let alone sit on it. I also want to suggest, some people say, oh, Justice Thomas, you are a hypocrite. You are a beneficiary of affirmative action, and now you are pulling up the rug, and you are, in effect, a racial turncoat. You are a traitor to the race. I don't agree with Justice Thomas on affirmative action. That argument, in my view, has little to recommend it. It's the same argument that says that FDR was a traitor to his class because he was wealthy and favored progressive taxation. It's the same argument that says, at least narrowly conceived, that men benefit from sexism, and so they should try to promote sexism. That can't be right. So if it's your view that the program violates the Constitution of the United States and delays justice, then it's his responsibility to interpret the Constitution by his best lights. Hypocrisy doesn't enter into the equation. I do want to suggest Justice Thomas should not be viewed as a black nationalist, as some people have suggested. He had a flirtation with black nationalism when he was in college, and some people have said, you know, Justice Thomas's views on affirmative action are consistent with, Stokely Carmichael. Well, I think it's a bit more complicated than that. Last time I checked, Justice William O. Douglas was not a black nationalist. And so we should maybe complicate some of these easy views. I do not believe that Justice Thomas was victimized by affirmative action. I think he's, wrong on that score. Sadly, attending Harvard or Yale for law school for a long time was a prerequisite to being on the Supreme Court of the United States. So I think he's inaccurate on that front. I'm going to move now. I had something I wanted to say about Justice Kavanaugh and his concurring opinion about the 25-year sunset provision, but I'm going to move on in the interest of time. I want to step back and think about the Roberts Court and think about it in a larger context rather than just thinking about for affirmative action. We need to think about this decision, the Harvard College case, in conversation with the Dobbs decision from last term, which of course overturned Roe versus Wade. Roe versus Wade was decided in 1973. The Bakke decision was decided in 1978. That means in two successive terms, the Roberts Court has overturned precedents from more or less half a century that were of vital importance and whose outcomes have been cherished by legal liberals for decades. The court delivered a 1-2 punch in successive terms of the sort that I have never seen in my lifetime. This court is not modest and incrementalist, but instead is throwing haymakers. I hope that if nothing else, this decision will lay to rest the notion that the Roberts Court is a conservative institution, because it has made painfully clear that it is uninterested in conserving large parts of our constitutional order. The court is not conservative. It is instead radical. It's a radical institution that has destroyed large parts of our constitutional order. Turn now, with the time that I have remaining, to thinking about the future of this area and thinking about SFFA versus Harvard. It's really not the end of something, but instead the beginning of something. We are poised for many battles in what might be termed the affirmative action wars. There's a case out of Northern Virginia involving a wonderful high school called Thomas Jefferson, TJ for short. Recently, Thomas Jefferson changed its method of admission. Before, it was a standardized test, and that standardized test resulted in very few Black and Latino students attending Thomas Jefferson. Some of the best law students that I've ever taught went to Thomas Jefferson. It's a school for the sciences. And they changed the method, and they tried to draw on Fairfax County, where Thomas Jefferson is, and ensure that people from all over the county, all different junior high schools would eventually show up at Thomas Jefferson High School. They paid attention to socioeconomic status, who qualified for a free and reduced lunch, who spoke English as a second language. The transformation in who's admitted to Thomas Jefferson took the enrollment of Asian Americans, and it changed the racial composition. Yes, Black and Latino students were many more admitted to Thomas Jefferson, but it took the Asian American enrollment from in the 70s to the low 50s. And this led to a claim that this was racial discrimination. And so this raises the question of what is a discriminatory purpose? Mind you that in the new Thomas Jefferson plan, there are no boxes being checked, there are no racial classifications, but was the change in plan attributable to a discriminatory purpose? That case may well make its way back to the Supreme Court of the United States, and there are definitely 3 votes to say that this violates the Constitution. Those 3 votes are Thomas, Alito, and Gorsuch. The question is whether 3 of their fellow Republican-appointed justices will join them to say even race-conscious decision-making, if there are no boxes being checked, violates the Constitution. So far, I've been mostly doom and gloom. I do want to add, though, at least sometimes when God closes a door, he opens a window. And so SFFA versus Harvard could accelerate a rethinking of college admissions and indeed what constitutes merit. It will, I hope, lead many universities to revisit the odious practice of legacy admissions, whereby the children of alums get a leg up in the admissions process. Sorry, Claire, I hope you don't get a chance to take advantage of legacy admissions. I've said in the past, supporting legacy admissions is a little like rooting for Elon Musk to purchase the winning lottery ticket. Someone who has everything gets just a little bit more. I also hope that the universities will reconsider country club sports, niche sports, boutique sports, which serve to depress racial integration on our campuses. Sometimes we think of college football and college basketball, but there's a lot of fencing, there's a lot of lacrosse, and those sports have a detrimental impact on race. Also, the children of faculty. Again, sorry, Claire. Those preferences do not help race. It may invite a rethinking of standardized tests and whether those are necessary. Many schools went to test optional during the pandemic, and perhaps many universities will be skeptical of standardized tests, and we will see the rise of adversity essays rather than diversity essays. We should not be mistaken, though. Changes in these areas will not yield the racial diversity in higher education that existed under Bakke and Grutter. States are, it's been said, laboratories of democracy. That's a phrase that's been attributed to Justice Brandeis in the New State Ice dissent, laboratories of democracy. And we've been conducting an experiment in California and Michigan, and the beaker of racial diversity has repeatedly blown up. That is to say that racial diversity in California and Michigan, which banned affirmative action some time ago, have seen their enrollments of Black students plummet. 10 years after California banned affirmative action, in the freshman class at UCLA, 5,000 people in that freshman class, 96 Black students. In 2021, Berkeley had close to 7,000 students in its entering class, 258 black students, 27 Native American students. Story is similar in Ann Arbor. Do you really think for a moment that the administrators in Berkeley and Ann Arbor were uninvested in the project of racial diversity? They invested immense amounts of money in trying to combat the end of affirmative action, and they have precious little to show for their efforts. It's possible that this is a story of numbers and that the smaller the institution, the easier it will be to meet the moment. But in my view, it would be disturbing if racial diversity on college campuses became a luxury good, something that exists only at small private institutions, and that large public institutions have, just trivial numbers of students from underrepresented racial backgrounds. And even that view, racial diversity as Louis Vuitton, runs into some real difficulties. There was a brief that was filed by elite liberal arts colleges, and I'm going to leave you with this. There was a brief that was filed in the Harvard case, filed by elite liberal arts colleges, including Amherst, Williams, Swarthmore, and many of the other very fine liberal arts colleges in this country. They say that if affirmative action were to be ended, anticipating the Harvard case, that it would have a drastic resegregating impact on our student bodies. And then they went on to quote from a book called The Shape of the River by Bowen and Bach, very important book for students of affirmative action. They say that a decision ending affirmative action would presumably take black enrollments back to early 1960s levels. If that prediction proves true, I fear that those of us who spend significant time on university campuses will soon be forced to hearken back to Seattle, Washington in 1963, some 6 decades ago now, and say with President Charles Odegaard, "Where are the black students? Where are the black students?" Thank you.
Professor Driver, I'm honored to field some of these questions. This first question is truly an omnibus. Is this court the worst court we've ever had?
It's a good question. Many people would say that this court is the most conservative that we have seen in generations. And it is a distressing court. And I fear that notions that there is anything like the law that is worthy of applying, that sit outside of one's political priors, is a vanishing idea. For a long time, the notion that the president who appointed a justice and the ideas that they would bring with them to the court, that was not a perfect match. These days, those two things are completely overlapping. One of the most remarkable things about the Supreme Court is that there was a period in time during the 20th century when 10 Supreme Court justices in a row were appointed by Republican presidents. Thurgood Marshall joins the court in 1967. Ruth Bader Ginsburg joins the court in 1993. And between those moments, 10 justices in a row were put on the court by conservative justices, but many of them did not vote the way that the Federalist Society would have wished for them to vote. These days, those views are gone. This became such a prominent view that Justice Thomas is purported to have said shortly after he joined the court, "I ain't evolving." you know? The notion is sometimes justices would come to the court and they would sort of, you know, meet people from around the country and they would evolve in their views. I ain't evolving. You might say Justice Thomas is a man of his word. You might also say he has changed in some respects. He's more conservative even than he was in the early 90s. Okay, next question, please.
This comes from online, and it's also a general question about the court. What is your opinion about the possibility of increasing the number of justices, i.e. court packing?
It's a very good question. It's one that has received a lot of attention of late. President Biden appointed a commission to study the Supreme Court of the United States and to look at what people would call court packing or court expansion for its proponents, along with term limits for Supreme Court justices rather than serving for life. People would be on the Supreme Court for 18-year terms. This is a very difficult question. Some people express the view that if President Biden were somehow able to get through a court expansion bill, that we would go to 15 justices, and then we would go to 21 justices, and then if you flash forward in another 50 years, there would be 100 Supreme Court justices. And many people would say that's unattractive. President Biden has demonstrated no appetite for expanding the court. And as you all know, it's very difficult to get things through the Hill. And so this is an interesting intellectual question, but it's a descriptive matter. It doesn't seem to have any legs. So that's where I'll leave my answer. Thank you.
This combines two audience questions, but I think they're related, and they go to affirmative action, as you covered in the lecture. If African American enrollment in elite colleges will drop dramatically now following the SFFA decision, doesn't that prove that the decades since Bakke were not successful? And the other question is whether in a diversity valuing regime, whether a wealthy student of color should receive preference in the admissions process over a poorer white student?
Listen, that's an important question. It's a very important question. And, President Obama had something to say about this. Let me back up for a second and tell you about what Justice Thurgood Marshall had to say about this, and then I'll tell you what President Obama had to say. This question arose as the court was considering Bakke in the 1970s, and Justice Brennan, Thurgood Marshall's dear friend, said, what about your son, Goody? Should he be able to get a leg up in the UC Davis Medical School? And Thurgood Marshall did not miss a beat, and he said, damn right, they owe us. President Obama was asked about this in 2008, about whether Sasha and Malia should benefit. And he was far more equivocal in his response and said exactly as the questioner did. There are people, white people from modest backgrounds, who don't have the advantages of growing up in a household with 2 Harvard Law School graduates. And it would be, odd if they were to benefit. Now, who knows what was driving President Obama's answer and its comparison to Justice Marshall's? A lot of time had passed between those two responses. And it's also true that President Obama was hoping to win a lot of votes. And that's not something that Thurgood Marshall had to worry about. So maybe that's some of it. As to the idea that black enrollment plunging suggests that affirmative action was a failure, that seems to me to be one possible way of viewing it. That's not the view that I would take. I would have thought that the more compelling view would be that there have been atrocities visited on black folks in this country that are enduring, and that it is a mistake to change the regime. I'll talk about what Justice Marshall had to say, also at Bakke. He was asked, how long should this program last for, by one of his more conservative colleagues. And Justice Marshall responded, affirmative action should last for 100 years. So that was Justice Thurgood Marshall's testament as to how long it would take for affirmative action to be necessary. And of course, Thurgood Marshall was the heroic lawyer behind Brown versus Board of Education, Mr. Civil Rights, as he was called. And he had a good measure on racial injustice, racial inequality that exists in American society, and that I'm sorry to say is not a thing of the past.
An online question. How do you think the legal challenges to legacy preferences will play out? And if they are followed by legal challenges to economic status preferences, how do you think those would play out?
Very good question, and it requires some distinction between the constitutional answer and the statutory answer. These claims about legacy admissions or preferences for donors would be very unlikely to gain traction under a constitutional objection. A majority of the court would say the 14th Amendment's Equal Protection Clause says something special about race. They disagree about what it says about race, but it says something special about race. And that's not true about where your folks went to college or how much money you have. Discrimination on the basis of wealth looked like it might receive some relief from the Supreme Court in the 1970s, but that did not gain traction. A more promising avenue for reform would be the statutory claim, looking at, again, Title VI of the 1964 Civil Rights Act. And the Biden administration's Education Department has launched an investigation into these sorts of measures. And one could imagine many general counsels at universities sort of encouraging their colleges to abandon legacy admissions in order to avoid the specter of litigation. And that might encourage them and give them cover for something that they want to do anyway. That is to say that many alums would put enormous pressure on their universities to say, this is the Harvard way. It's been in our family for generations. How dare you change the rules? But if Harvard can turn around and say, don't blame us, the law made us do it, that may give them a nice out.
An audience question from someone who's involved with early childhood education. In a community where only 3% of African American students are performing at grade level, the questioner says it is not because these kids aren't talented, it's because the schools do not provide a strong education. It's a resource, quality of school question. Why don't we have lawsuits demanding equal education?
Great question. The answer is we did. And it looked as though such relief was going to be granted. There's a case called San Antonio Independent School District versus Rodriguez that was decided by the Supreme Court in 1973. I write about it extensively in my book. And when that lawsuit was filed in 1968, it was a claim suggesting that students in the poor part of town, Edgewood, received a lot less funding per pupil than in the wealthy part of town, Alamo Heights. Students in Edgewood were overwhelmingly Mexican American. Students in Alamo Heights were overwhelmingly Anglo in the terminology of the opinion. When that lawsuit was filed in 1968, liberals and conservatives alike said, the court is definitely going to side with Rodriguez and the poor students and require an egalitarian approach to school funding. And they said, the Warren Court is in charge, and the Warren Court is all about egalitarianism, and so this is a surefire winner. Again, there were conservatives who said, much as it pains me to say this is going to win under the Equal Protection Clause. What happened between 1968 and 1973 when the Supreme Court issued the opinion? President Nixon happened. And President Nixon got 4 Supreme Court appointees in a very short period of time, and all 4 of those Supreme Court appointees voted to uphold the school financing regime and are opponents of school equity. The story's not quite as grim as I've made it seem so far. In Justice Thurgood Marshall's magnificent dissenting opinion in the Rodriguez case, the 100th and final footnote says, you have lost in the Supreme Court, but you should turn your attention to state courts who are interpreting not the federal Constitution, but state constitutions, and they may be able to grant you relief. And that has happened, including in Texas and Connecticut and many in New Jersey, thank you very much, and many other states as well. So, and that is a larger lesson in our current constitutional moment, that the Supreme Court of the United States is responsible for articulating a constitutional floor below which localities cannot fall, but nothing prohibits state legislatures or school boards or state Supreme Courts from offering additional layers of protection. And for we liberals, this Supreme Court ain't going anywhere. And so it's a good idea to turn your attention and your requests for reform elsewhere.
So unfortunately, we only have time for one question, but I want to take one more question, the opportunity to recommend your book to folks, because I think a lot of the questions we saw coming in that we can't get to, you're going to find a discussion of in this marvelous book, which we'll have a signing for over at the Hall of Missions. That's my personal recommendation of a wonderful, wonderful book. So we're going to ask one last question and then move to the book signing.
It actually combines 2 questions. But this is a series of questions about the dominoes. What do you think SFFA will mean for faculty hiring, administrator hiring, program design and education, and also in the realms of public contracting, minority business set-asides, et cetera, with expenditures of government funds?
It's safe to say that what starts in the realm of education will not stay in the realm of education. And as I suggested a moment ago, the specter of litigation exists over many programs in the employment world, including minority business contracting and faculty hiring as well. So this is something that is a decision that is going to have a cascade effect in many areas of life. And in the states that have enacted measures that eliminate race-conscious decision-making, they have seen precipitous falls in these sorts of racial equity measures in other walks of life. Let me just step back for a moment to say how tin-eared, even tone-deaf, the Supreme Court's opinion was in this area. It seems to me that George Floyd's death sparked a racial reckoning around this country. Many people took to the streets to say we've got to do a better job when it comes to race and equality that exist in America. And the Supreme Court of the United States, in the long George Floyd era, has rushed headlong in the opposite direction, and it's going to, I fear, delay much of the progress that was on the horizon. Thank you very much. I really enjoyed my time with you.
CHQ Assembly is made possible through the collaboration and innovation of Chautauqua institutions' full-time and part-time staff, seasonal staff, and many volunteers, as well as participants like you, whose engagement, gifts, and subscriptions sustain our mission.